Thank you very much, ladies and gentlemen. I begin by acknowledging the traditional owners of country, the Gadigal peoples of the Eora Nation, upon whose land the Sydney Law School stands, and I pay my respects to elders past, present and emerging, and I acknowledge that this is unceded land. Welcome to the Paul Byrne SC Memorial Lecture for 2022. My name is Andrew Dyer and I am a member of the academic staff here at the University of Sydney, and I am a director of the Sydney Institute of Criminology, which, as many of you would know, is a research centre based at this law school and peopled by academics who are specialising in criminal justice research. As I say, we're delighted to welcome you to the law school today, and we're also delighted that we're finally in the position again to have the Paul Byrne Memorial Lecture here. Because of pandemic restrictions, we were unable to have the event over the last couple of years, and so it is fantastic to be able to welcome you all back to the law school. And this lecture is supported by the Paul Byrne SC Memorial Fund, which was created about a decade ago with the aim of honouring Paul Byrne's contribution to the criminal justice system by supporting the Sydney Institute of Criminology's activities, including lectures such as the one that we are about to hear today. Before I introduce the speaker for tonight's event, I acknowledge Jack Byrne, who is in the audience tonight, Paul's son. It's been a pleasure working with Jack, as usual, in the organisation of this event. And I also acknowledge a number of members of the New South Wales judiciary in the audience tonight. First of all, the Chief Justice of New South Wales, Justice Andrew Bell, welcome to the law school. Welcome also to the Chief Judge at Common Law, Justice Beach Jones, and also Justices Adams and Dangy of the New South Wales Supreme Court. We also acknowledge in the audience today Judge Dina Yehia of the District Court of New South Wales, who gave the last Paul Byrne Memorial Lecture in 2019, and also Acting Judge Jeff Graham of the District Court of New South Wales. The Speaker, Justice Hamill, was sworn in as a judge of the Supreme Court in April 2014 after a distinguished career as a criminal lawyer. After working as associate to Justice Mary Gaudron in the High Court of Australia, he was called to the bar in 1988 and spent 25 years at the bar, mainly dealing with criminal matters. During his career at the bar, Justice Hamill appeared at all stages of the criminal justice system, from the local court to the High Court of Australia, including in some 150 criminal appeals. He also worked on some of the state's most significant coronial inquests and judicial inquiries involving individuals such as Kelly Lane and Fong No, and he is known for a bold and humane approach to the law. Justice Hamill acknowledges Paul Byrne as being one of his most important mentors, and he will be speaking about Paul Byrne, the lawyer, and the person tonight. We welcome him to the stage. Thank you very much.
Hello, everybody. Can I first testify to the terrible wrongs that have been perpetrated on the traditional owners of the land on which we gather? I acknowledge tens of thousands of years of custodianship of this land by the Gadigal people of the Eora Nation. I pay tribute to the elders and leaders of the Gadigal, past, present and future. I acknowledge the extraordinary resilience and good humour of the people. As Tila Reid said in her Welcome to Country at the swearing-in of our new Chief Justice, Andrew Bell, I acknowledge this country. I acknowledge that it always was and always will be Gadigal land. Their sovereignty was never ceded and coexists with the sovereignty of the Crown. Ms Reid tells me that the University of Sydney, near what is now known as Victoria Park, was a significant site for First Nations people. The name Gadigal is taken from the Gadi tree fern, which is a significant plant in the area and its waterways, and it's symbolised by the new Cuddy Garden here at the law school. A student of the university, A. Kochian, in his paper Rethinking Gadigal Land and the University of Sydney, wrote that the quadrangle actually sits atop a sacred site. He wrote that Wiradjuri man Dennis Foley was told by his grandmother that the Great Hall and the Macleay Museum stand on what is part of a Cadigal cemetery, and his nan wondered why it was always so cold there. Dr. Wendy Brady, writing the university's student magazine in 1998, said the whole of Victoria Park, which is just over there, was corroboree ground. In his 2011 book, The Biggest Estate on Earth, Professor Gamage said that the area around Sydney University was called the Kangaroo Ground. It was almost certainly a gathering place with fertile soil where yams and yam daisies were essentially cultivated, as were most of the riverbanks around Sydney. This is history we are not taught. We are hopefully on the cusp of some change, with the possibility that the federal government will seek to implement the Uluru Statement. As the Uluru Statement says, the First Nations people here are the most incarcerated people in the world. We live on land that was taken by conquest, not by settlement. There are hundreds of sites around Australia where horrific massacres took place. We have to strive to do better. We have to strive to use our positions of privilege to effect change. Paul Byrne was somebody who tried to use his position of privilege to effect change, and I acknowledge again the Cadigal people and their land. So why are we here gathered on their land? Well, Paul Byrne died on the 12th of May 2009. He was 58 years old. In the winter edition of the Bar News, which is the quarterly rag published by the New South Wales Bar Association, there was a fine obituary published by Judge Steve Norrish QC of the District Court. Judge Norrish described Paul Byrne as the most outstanding criminal law of his generation, and that was an apt description. Paul, who knew that he was going to die, gave clear instructions that he wanted no fuss and he wanted no ceremony. According to his wishes, there was no public funeral and no public commemorative service. However, not very long afterwards, the Chief Justice of the day gave permission to hold a ceremony in the Banco Court on level 13 of the Supreme Court building, or the Law Courts building in Queen's Square. Many of us gathered to remember Paul, and there were good speeches delivered by his son Jack, who is here tonight, of course. People like Michael Kirby, former Justice of the High Court, Steve Norrish, and Gabby Bashir, now the President of the New South Wales Bar Association. I welcome her also. Later, the idea was hatched to remember Paul in the longer term by this series of lectures that bear his name. The first lecture was delivered by Justice Michael Kirby. It was entitled Homosexual Law Reform in the Commonwealth of Nation, An Impossible Dream. And since then, several highly distinguished lawyers have spoken here. There's a list of them, and you'll see that that list includes 4 High Court judges, a prominent civil libertarian, Terry O'Gorman, and one of our most distinguished criminal lawyers, Phil Bolton of Senior Counsel. I'm very honoured to follow the most recent speaker, my dear friend and colleague, Judge Yahya SC, who spoke in 2019. I just ask you to excuse me while I have a drink. I have to negotiate this part of the speech. Anyway, Dina I was going to acknowledge the wisdom of our current Chief Justice at this time, but I'll acknowledge that anyway, but I'll keep short my remarks otherwise. Judge Yahya's contribution to the law and to the community is extraordinary. It includes most recently the establishment of the Wallamar list, a sentencing process for First Nations people. She has earned the nickname Spicy DCJ for her efficient conduct of super call-overs and the unwieldy list in Court 3.1 at the Downing Centre. Her contributions to the Western Aboriginal Legal Service are legendary west of Bathurst, and she was one of the finest public defenders of the last 2 or 3 decades, and that really is saying something given the quality of the barristers that have worked out of that office. Anyway, that's probably enough about Dina, who is a Boston Red Sox fan of many years standing. So it is an honour to follow her. I also acknowledge many of the distinguished guests here tonight. I thank the Chief Justice and the Chief Judge of Common Law for their presence, probably just making sure I don't say anything too outlandish. Good luck with that. And also the Commonwealth Director of Public Prosecution, Sarah McNaughton, I'm delighted to see tonight here as well, and I think she would probably echo a lot of the things I'm going to say about Paul Byrne and the way he conducted himself in every aspect of his life. So I, having been told that I was to follow Dina, I had to think about what I might speak about and realised, looking at the list that was up a moment ago before Dina took over, I realised it was to be the 10th year of the lecture series, and perhaps it would be useful or nice to take a break from the worthy and important topics that have been spoken about by previous speakers and to pause and remember the man himself. And so I decided that is what I would do. So I'm going to speak to you tonight about Paul Byrne, his remarkable contributions to the law. I'll focus on the lessons to be learned from some of his more important appeal cases, but more significantly, I think, from his wonderful life, his approach to the practice of the law, his generosity, his courtesy, and his attitude to people. Along with many others, a number of whom are in this room, I was lucky enough to learn from him directly. And my ambitious hope tonight is that some of you will learn something useful, something practical, maybe even profound, but not from me, but from Paul. So if I can, I'd start with some biographical information. Paul was born in Adelaide on the 12th of October 1950. His family moved to Sydney about 4 years later. Paul attended local public schools and ultimately did his high school at North Sydney Boys High. The family moved to England for a period, and I'll make that relevant later. He attended this Sydney University and he graduated in 1976 with a Bachelor of Arts and a Bachelor of Laws. He had by that time worked as a clerk for the Public Solicitor's Office and had come to the attention of the then Senior Public Defender, Howard Purcell of Queen's Counsel. He continued to work with the public solicitors for a time after he was admitted as a lawyer. He was called to the bar in 1979 at the age of 29 and was appointed as a public defender, where he worked for a number of years with some great, truly great defence lawyers like Peter Hidden of Queen's Counsel, Steve Norrish similarly, both of whom would become judges, but neither of whom ever forgot where they came from. Steve Norrish recalled in the obituary I mentioned at the outset that year after year Paul won a trophy which was given out for the most industrious public defender. He went to the private bar, starting in Frederick Jordan Chambers in 1988, where he joined people like Ian Barker, Queen's Counsel, and Virginia Bell, who went on to do some stuff. And as the leader, they were the leaders, I suppose, of the civil liberties and criminal defence part of Frederick Jordan Chambers. That's where I first met him. But he left, along with a number of us, to found Forbes Chambers, where he remained for something like 20 years. And that's really where I came to know and love him. Right towards the end of his time at the bar and his life, he moved to Samuel Griffith's Chambers, where, again, he was just greatly loved. Jumping backwards, if I can, Paul became the director of the Attorney General's Criminal Law Review Division and a full-time commissioner of the Law Reform Commission. That was in 1984. This was at a time when law reform in the criminal law involved something other than increasing maximum penalties and standard non-parole periods, or imputing or expanding the scope of criminal liability by imputing intent where there was none. Paul achieved a lot in his time as an advisor to the Attorney General, but his greatest contributions remained ahead of him. In 1983, he completed a Masters of Laws with first-class honours, and he received the University Medal. His thesis concerned the dangers of identification evidence, and the ideas that he there canvassed would find critical voice 10 years later when the High Court published its judgment in Domican against the Queen. And that is the first of Paul's great big famous High Court cases to which I will refer. It was not the first chronologically, but Paul's contribution to the law as a barrister can be gleaned from a review of his cases in the High Court, early on as a junior, but most often as a leader. Now, I realised after I had prepared this speech and that I had missed a number of his cases, and at least in one case, I think I had blocked it out because it was such a shocking loss for us. But there are, just there alone, an amazing array of cases of great importance. And I'll come back and I'm going to talk about his High Court cases. But before I do, I just want to interpose three things. The first concerns Paul's early work. When news got out that I was to give this speech, lots of people called and wanted to talk to me about Paul's impact on their lives and on their careers. One such person was Justice Peter Johnson. Peter Johnson has just left the Supreme Court after an extraordinary 17-year career on the bench. Peter is quite a scholar, and I don't think he throws very much out. And that's a trait he shared with Paul, but he left this beautiful note on my desk. And attached to it was this remarkable thing, which was something that Paul had created in his early time. And it'll be there. If you feel like looking at it, don't spill red wine on it, because I think I should give it back to Justice Johnson. But it's a very dense summary of recent law, criminal and civil, prepared by Paul when he was a public solicitor. It covers scores of topics in closely typed, and I mean typed, actually typed, pages. It speaks volumes of Paul's work ethic, and that's one of the things that I want to urge you to consider to be a key lesson from Paul's professional life. That was in 1978, according to Justice Johnson. I still call him that. And he didn't stop working hard for his colleagues and his clients until weeks before he died in May of 2009. The second thing I want to mention before I turn to Domican is to explain the title of tonight's lecture. I call it "They're All Good Cases" because this was perhaps the most valuable lesson that Paul taught me. And I'm going to indulge myself there with a shiny suit. I think it's fair to say that I was quite an anxious barrister. I tried to hide it in court and in conference with clients and solicitors, but I shared my anxiety rather too readily in chambers. I think the Chief Judge at Common Law is probably thinking nothing has changed at this time. And so might others, my neighbour Natalie Adams, I'm sure. But this is not a fault that Paul shared. Quite to the contrary, he was always calm, or always seemed calm. I asked him once, driving back from Canberra, how are you so nice all the time? How do you never get stressed? And he said, you don't see me at home. Well, my guess is he was really lovely at home too. But drifting back to the title of the court, it stemmed from an occasion, maybe more than one, when I was in Paul's room having a meltdown about some judge or some solicitor or some prosecutor or some client or some case I couldn't possibly win. Well, whatever it was, I was in full-blown whinge mode. And Paul heard me out, as he always did, calmly. At some point in my diatribe, I paused, and Paul looked up at me quizzically and spoke kindly and gently without judgment and said, they're all good cases. And I thought, that is an extraordinarily profound statement. I've never forgotten it. When I'm overrun with judgments, I try to cling to it. They're all good cases. When Paul said it to me that day, and as I say, it was without any judgment, it meant so many things. It meant this is how you earn your living. Be grateful for it. And it meant there's always some argument, some point you can make if you keep working. Just do that bit of extra work. And it meant this case is critical to an individual, to your client. But most of all, it meant we are so privileged to do this job. Try not to forget it. Our work is so interesting. It may be stressful, but it's never boring. So don't waste your time worrying about it. Have some fun. Appreciate how lucky you are. Enjoy the privilege of defending people's rights. You'll have to excuse me. And the last thing, the third thing that I want to interpose before coming back to Domican and Paul's win there, sorry, that's a spoiler, is why he was a mentor to so many people. I was one of the lucky people to whom he was a mentor, but my other great mentor was Justice Mary Gaudron. And what I say here is, and again, I'm delighted and very touched and honoured that she is here with us tonight, but she's not. We arranged for her to come here and then to have dinner, and she texted me, or called, she doesn't text actually. The government might be watching if she texts, but she called me and said that she wouldn't make the speech, but she'd see me at the restaurant. So she showed some judgment, I think. But anyway, she would hate what is about to happen, but in any event, she was another Sydney University medalist, and she went on to achieve a few things in the law. And her advice to young lawyers was, and remains, she said it to almost all of my associates over the last 7 years, and her advice was, get out there and make trouble. That's the very least you can do. And I don't doubt for a moment that Paul Byrne would have utterly approved of that. I think it fell within the umbrella of his wise words to a stressed out young barrister all those years ago. They're all good cases. And so how do I tie that together and those two disparate things? It's because Justice Gaudron was one of the authors of the joint judgment in Domican and the Queen. Tom Domican was convicted by a Sydney jury for shooting at a gangster called Christopher Dale Flannery with intent to murder him. The prosecution relied upon circumstantial evidence, but critically on evidence of identification by Mr. Flannery's wife, She said the gunman was Mr. Domican, but she did not know him, and that identification came something like 9 months after the shooting. There were other weaknesses in her testimony that were drawn out and emphasised by counsel at the trial. The shooter was wearing some sort of silly disguise. The observation was fleeting. And the trial judge gave full directions about all of that, but he didn't emphasise and give his own support to or imprimatur to the weaknesses that had been raised on behalf of Mr. Domican. Paul Byrne in that case was led by Peter Hidden of Queen's Counsel, and Paul made the submissions in reply. The High Court held that the directions and warnings were insufficient to cure the potential dangers of the identification. It held that it didn't matter that the prosecution relied on evidence other than Mrs. Flannery. The court held that because it was possible for the jury to convict based on her evidence alone, that it was necessary for the judge to give strong and detailed warnings about the dangers, and it was insufficient to rely on counsel's argument. And that case can still be used today if counsel is not satisfied that a trial judge's summing up sufficiently emphasises the danger. I then moved to Saraswati and the Queen. Domican was not Paul's first win. He had previously, 2 years earlier, appeared in the case of Saraswati and in another case called McKinney and Judge. In Saraswati, the prosecution attempted to circumvent a 2-year limitation period on bringing charges of indecent assault where the victim was aged between 14 and 16. The prosecutor charged what was undoubtedly an indecent assault, if believed, as an act of indecency to sidestep the provision. And a majority of the court held that the legislative scheme could not be used in that way because the true offence was statute barred. And that case remains important, albeit that the legislation has been changed about 40, 50 times since. But it remains important as a question of statutory construction and on the use of a prosecutor's power to selectively frame an indictment to dodge a legislative protection within a penal statute. McKinney and Judge was a case that changed the face of policing in New South Wales. It was a matter of great notoriety in the late 1980s that convictions were often secured by what was known, not really lovingly, as a verbal, and that is in the absence of any actual evidence of guilt, the police would concoct or fabricate admissions. Sometimes they were signed, sometimes they were in writing, sometimes they just relied on the policeman's say-so, and the situation had become quite scandalous. Well, Peter Hidden and Paul Byrne and the majority of the High Court put paid to that. Both Messrs McKinney and Judge had signed confessions while held in involuntary police custody. And they admitted in those confessions their involvement in what these days would be called a serious home invasion. The majority, Justices, Chief Justice Mason and Justices Dean, Gaudron and McHugh, revisited the issue of such confessions which had been discussed a few years earlier in a case called Carr, where a minority, being Justices Gaudron and Dean, had said that warnings about this kind of evidence should be given. But as I speak to you, just have a look at some of that language. It's beautiful stuff and we don't see it as much as we maybe should. The majority stressed the position of special vulnerability of a suspect in police custody. It stressed the fact that by then there was electronic equipment that could record these sorts of things. It's difficult now looking back to appreciate the significance of McKinney and Judge. These days there's rules of admissibility within the Evidence Act, and these sorts of pieces of evidence wouldn't probably even get before a jury. But in the early 90s, it was critical. And really, as I said earlier, it had become a scandal. And Paul, who quoted the work of the Law Reform Commission in his submissions to the full bench, played a very important role in that. So I'm now going to tell you about something quite different, and I'm moving away from the High Court for a moment to tell a tiny part of the story of the life of a man called George Patrick O'Neill, and the part that Paul played in ensuring that he did not spend a moment longer in custody than he should. It's worth telling because within the story it has one of the lessons to be learned from the way that Paul Byrne practiced law. Mr O'Neill and his wife were out drinking one night in Wilcannia, and they were both real drunk. They got into a row and there was some physical contact between them. Some witnesses said that George threw a punch. Others said he pushed his wife away. George said he pushed her away just to get away from her because she was wild. Tragically, his wife fell backwards, struck her head on a garbage bin, and she died. Mr O'Neill was charged with manslaughter by unlawful and dangerous act and was convicted by a jury in Broken Hill. At that time, there was a conflict in the authorities around Australia as to what constituted a dangerous act for the purpose of manslaughter. Some cases or some states held that all that needed to be proven was that the act carried a risk of some harm. Other states held that it needed to carry with it a risk of serious injury. Eric Wilson, then of the Western Aboriginal Legal Service and later a long-time public defender, asked for a direction that the prosecution must prove the second higher test. And over Mr Wilson's protest, the trial judge told the jury that an act was dangerous if it was likely to cause more than trivial harm or more than negligible harm. Now, Mr O'Neill appealed against his conviction, and by that time the issue of that conflict in authorities was before the High Court in a case called Wilson and the Queen. And I appeared on George's bail application, and I thought we just have to get bail. I mean, if the High Court rules for the stronger test, George's conviction has to be quashed. And as often happened, I was wrong. The Supreme Court judge in the Bails Court was unimpressed with the conflict in authority and not impressed by the fact that George would have finished his sentence by the time the High Court decided the Wilson appeal, and the application was refused. Well, I was outraged by this. I still am. Luckily, I went back and shouted and screamed through the phone to the Western Aboriginal Legal Service, who said, yeah, all right, we'll appeal to the Court of Criminal Appeal against the bail decision. And luckily, I also convinced them to get Paul Byrne to lead me, because the problem was there was no power in the Court of Criminal Appeal to entertain a bail application or an appeal from a bail application of a Supreme Court judge's decision. I just, in my fury, completely misread the Act. So the matter came on before the then Chief Justice of New South Wales, Murray Gleeson. Now, Murray Gleeson was a great judge, and I would say an even more formidable barrister, but he could be very incisive, and I found him just a little bit scary. So the case started, of course, with the Chief Justice attacking the very process by which we were in the courtroom, suggesting there was no power for the court to even entertain this so-called appeal. Now, I was panic-stricken until I saw Paul opening the Bail Act at what was then Section 30 and read to the court the provision which gave the CCA original jurisdiction, not appellate jurisdiction, to hear an application in an appeal that was pending in the court. And whilst His Honour, the Chief Justice, was catching his breath and looking a little bit admiringly at Paul, Paul turned to Section 22 of that Act and said, very gently and quietly, all applications to a court in relation to bail shall be dealt with as soon as reasonably possible. And then he said, quietly but assertively, we're all here, Your Honours, and I invite the court to deal with the matter under Section 30 in accordance with the command in Section 22. And the court did what it was told, and George was released from jail, and the High Court made its decision in Wilson, defining dangerous act as an act carrying with it an appreciable risk of serious injury. He got his retrial. He was put to trial again in Broken Hill. I was privileged enough to be there when he was found not guilty of the homicide of his beloved wife, and it remains one of the most cherished moments of my career. George was a huge man, and he just started sobbing uncontrollably in the Broken Hill dock. It wasn't because he didn't have to go back to jail. George could have handled that. It was because a jury had said he did not unlawfully kill his wife. So what do we learn from that? I think the first thing is don't panic in the face of a hostile reception from the bench. Stay calm. More importantly, and Mary would be utterly ashamed of me for having to say this, having learnt it that way, always know the source of the court's power and jurisdiction. I suspect Paul knew that I'd made the application under the wrong section, just hadn't bothered to mention it, and I expected he was anticipating the torrid reception that he received, that he was ready for it. And of course, it wasn't the slightest hint that it was me that had made the mistake. There was never a chance he was going to throw me under the bus that day. I see Gabby Bashir nodding and smiling at me at this moment. Didn't matter who'd buggered up the paperwork. All that mattered was that George Patrick O'Neill should get bail, and he did. And the calmness and generosity that he exhibited to me that day was one of the many reasons that we all loved Paul Byrne. And I'll return to that. But I want to tell you another story about Paul's superior preparation, which allowed him, again, to be just a little bit cheeky in the New South Wales Court of Criminal Appeal. So now I'm going to talk to you about Henry and the Queen, which is a guideline judgment on armed robbery. In 1999, the Court of Criminal Appeal, under the leadership of Chief Justice Spiegelman, decided a series of cases where guideline judgments for frequently occurring offences were pronounced. And the first one to come before the court was about armed robbery. It still gets quoted almost every day, I think, in the district court. There were 5 offenders whose cases had been selected, lucky them, and I was to appear for Mr Henry, and Paul represented a young man called Mr Tran. The court was, the appeal was heard by 5 judges of the bench, and the case went over, 3 or 4 days. And the most junior judge on the bench was a judge called Justice R.S. Hume. He retired not very long ago as perhaps the most senior, I think, or one of the most senior common law judges, and sadly has now passed away. In 1999, Justice R.S. Hume was not the most vastly experienced criminal lawyer, but he was a formidable man. And not many people share this view, but I always thought he was funny. I once got in trouble for saying good morning in a courtroom, which I thought was hilarious. And I threw my pen down to cover up how funny I thought it was. But anyway, I'm going back to Mr Henry and Mr Tran. After the submissions relating to the general question of whether there should be a guideline judgment, if so, how much, how many years it should be, the barristers got to make submissions on their individual cases. And in the course of it, Paul described Mr Tran as virtually a first offender, and it was an ambitious submission. And I watched Justice R.S. Hume reacting. First he looked puzzled, like he'd missed something. Then he started flicking through his paper. And then he became quite agitated and started to kind of bounce up and down. I mean, as I say, he's a funny guy. And after a few minutes, he finally interjected and took Paul back to the submission that his client was virtually a first offender. And he started reading Mr Tran's criminal history out. And he said, but he's got convictions for drugs and guns and dishonesty. And Paul said, oh, Your Honour, he doesn't really have a record of significance, and pretended that he was just going to keep moving on. But Justice Hume was back into him and said, but what about this conviction for drug supply? And Paul said, well, you know, that was just a bit of cannabis. And then R.S. Hume said, well, what about this other conviction for drug supply? It says heroin on his record. And Paul said, there's nothing in that, Your Honour. That was just a couple of foils at the Cabramatta railway station. And then RSUM said, well, what about this conviction here for possessing a firearm? And Paul said, oh, Your Honour, that gun didn't even work. I wouldn't worry about that. Anyway, look, to be honest, it didn't go all that well for Mr Tran. None of the respondents, including my client, Mr Henry, did all that well out of that case. Mr Tran's good behaviour bond was increased to a short jail sentence, but Paul's rather courageous submission did find its way into Justice Wood's judgment. He said that he had a minor criminal record that was somewhat typical of a young drug abuser. I suspect that the former Chief Judge of Common Law may have thought Justice RSU was funny too. Anyway, so the point of that story and what we can learn from it is, again, preparation. Know your client. Be across all aspects of your brief. It's okay to be cheeky, but you've got to have the goods. Paul didn't just look quickly at his client's criminal record. He knew the facts of everything on that record. It was also a lesson in courageous advocacy. But again, his responses to RSUM were courteous and calm and utterly persuasive. So let me then return to the High Court. In the case of Crampton and the Queen, don't know how I'm going for time here. Anyway, there's a lot to talk about with Paul Byrne. Gabby Bashir was Paul's instructing solicitor in the case of Crampton, and she tells a nice story about the hearing and Paul's skill as a barrister. It was a case concerning statutory construction of the word with and about directions it should be given. And those were the issues that were taken to the High Court on a special leave application. Was it all run together in those times? So there was a separate special leave application. Anyway, Justice Gordram was presiding and she asked the first question, which was the tricky question, which was this: Mr Byrne, you have the difficulty, do you not, that this point has never been taken in any of the courts below? Now, Gabby had the same sinking feeling that I had sitting next to Paul in George Patrick O'Neill's would-be appeal on bail earlier, and she thought they were going to be hosed out in seconds. But on that day, at least, Paul Byrne had Justice Gordram's, or he was her match. He not only persuaded them to take the points that they had gone there to argue, but he also persuaded them that one of the critical points of principle that warranted the grant of special leave was the very question of when the court should grant special leave when the point was not taken below. And it stands as authority for that to this day. There's another example of Paul's agility as an advocate. Smith and the Queen is the next one. Most people know this case, but they may not know the way that Paul won the case. Mundarra Smith had been subject to identification evidence by police officers who said they'd looked at the CCTV footage of the bank robber and they knew Mundarra Smith and that was him. So, more importantly, they were expressing that opinion. The case had run all the way to the High Court on the question of Section 76 of the Evidence Act, which is an exception to the opinion rule based on lay evidence, and the question of prejudice under Section 137. And that's the way that everybody who rocked up that day thought the case was going to go. In fact, I had a message from Belinda Baker, who was appearing for the prosecution, and that's exactly what they thought was going to happen. But as we know, let's face it, the majority of the High Court is often much cleverer than anybody else, and they worked out their own way to acquittal. They said the evidence wasn't even relevant because the police officer's opinion could not rationally affect the fact in issue, that is whether Mundarra Smith was a bank robber. And Justice Kirby, in that ceremony in the Banco Court all those years ago, described what happened when Paul stood up, and I'm borrowing his words to some degree, that he was beset with questions from the court addressed to why the evidence was not admissible for a completely different reason to anything that had been argued before. And he said that Paul looked up with what he described as those thoughtful eyes, trying to work out how he could hold on to Justice Kirby but also grab the others who were firing these questions at him. And in the end, Paul managed to win over all of the members of the court. And Justice Kirby described it as a triumph of differential persuasion. And he said he could still see Paul that day accepting his, that is Justice Kirby's analysis on the one hand, and then without a blush turning to Justice Hayne and accepting his completely contrary and contradictory analysis. And Justice Kirby said that Paul's death deprived the court of an advocate who was greatly respected and admired. And he said he was also a lovely, lovely man. And so he was. Gray and the Queen. That was a case where the majority of the New South Wales Court of Criminal Appeal found no miscarriage of justice when the defence was not put on notice that a critical informant witness had received a letter of comfort from investigating police. Justice Simpson, who we also love, dissented. Her Honour insisted correctly, as it turned out, that it was not for an accused person to undertake some complicated detective exercise to discover material about such a fundamental matter going to a witness's credibility. Paul appeared in the High Court and I think comfortably persuaded the court that the ground of appeal itself was made out. But the problem was that there was a whole bunch of evidence that might have suggested that the case against the client in relation to his guilt was really strong. And it was a complicated factual case about car rebirthing and dealing with stolen motor vehicle parts. And there were a whole bunch of cars involved and lots of counts on the indictment and really long engine and chassis numbers that had been switched between various cars. And Paul and I had dinner the night before the case was heard in Canberra, and as always he paid. And as we spoke about the case, I got this unnerving feeling that his knowledge of the facts of the case was, I don't know, imperfect. And when he left me to finish the nice bottle of wine that he'd bought, I thought the best hope we can have here is that the court is not too preoccupied about the pesky facts. But this was the Gleeson High Court, and detail mattered. And Paul Byrne advocacy tip, it always does. So it was no real surprise the next day when the Chief Justice started by peppering Paul with a series of detailed questions. Which vehicle is that related to, and which count on the indictment? Which chassis number was on that car, and which engine number should have matched that? And why is that wrong? And how did it get there? And why was that important? And just what did that portend as to the likelihood that our client was not, I don't know, really, really guilty? Now, I grabbed for the appeal book and tried to work out where to start when I realised that Paul was answering every question with appeal book references, calmly and firmly bringing the court back to the fact that while all of that was terribly, terribly interesting, none of it mattered if the jury didn't believe the prosecutor's star witness. And again, the lesson is preparation. He knew every aspect of that brief, and it was quite incredible to watch. My guess is he didn't sleep a wink after he left me that night. So on that note, let's talk about motor cars. Let's call it Monterey, I think, Jack?
Yes,
yeah. Pebble Beach. Okay. Anyway, if there's one thing that Paul knew more about than law, it was racing cars. Perhaps all fast cars, maybe just any car with style and nice lines, but I think it's fair to say he was obsessive about racing cars, and especially Formula One. And it seems remarkable, but maybe it isn't really, that he was born in 1950, which was the first year that the Formula One World Championship was conducted. He had this most wonderful, tiny collection of perfect replicas of racing cars going back decades. And he had cars, and he had helmets, and he had paintings, and he had photographs, and he had books, and all sorts of memorabilia that just took over his chambers entirely. It was quite astonishing. He had a specially made cylindrical case made in perspex or glass to display the cars. There they are there. I used to play a game when I went into his room most times where I'd point at a car and ask which car that was or which race that one had won. And he always knew. He always knew the driver, he knew the year, he knew the event. Whether it be Le Mans, whether it be a particular Grand Prix, whether it be an IndyCar race, What's the one that goes all the way down America? The one that goes all the way down America? Maybe it was that one. Anyway, his knowledge was ridiculous. There's a question and answer after, Jack, so I hope you're ready for it. And it was infectious. I'm told by Jack that at one stage when Jack started quoting the history of Formula One and motor racing with the same anal retentive precision, Paul just looked up and said he never had a chance. There are some of his helmets. Paul was amused that I became a minor enthusiast, that I liked the red racing cars, which was referring to Ferrari. And I think of him every week or every other week during the Formula One season, and I wonder what he would have thought about this manoeuvre by a driver or that decision by the stewards. Just another way that I and so many people miss him, and we do miss him all the time. He was one of the kindest, most generous people that I have ever had the good fortune to meet. And I've realised over the last weeks just how many people feel the same. I used to think and sometimes say out loud that when I grow up, I want to be like Paul Byrne. But that's an ambition I've given up on. One, I've decided not to grow up. And secondly, I just have to accept that my temperament isn't the same as his, not as pure as his. Paul's son, Jack, tells me that he took his wife, Karen, to her first Formula One race the first year of their marriage, and that he went to the Melbourne Grand Prix. I knew this not very long before he died, when he was unquestionably too sick to go and no doubt had doctor's orders not to go. Jack shared with me that Paul's love of motor racing was born from his father's love of the sport. And one of Paul's first books was the 1958 to 59 Automobile Year. That book fell on hard times over the decades. It was tattered and torn, but it remained treasured, and of course it was never thrown out. In fairness, nothing much got thrown out. And eventually Paul had the book leather bound with the dedication from his father still in the front page, which said, "To Paul on his 9th birthday from Mummy and Dad, 12 October 1959. Now that year, Sir Jack Brabham won the Formula One World Championship for Cooper, the first Australian to do so. And as I say, Paul was 9 at the time, and the family was living in London, or just south of London, and his dad took the family to the 1960 British Grand Prix at Silverstone. That was Paul's first Formula One race. And he went to many, many more over the decades, all over the world. And Jack tells me that's at the Spa circuit in Belgium. But going back to that day in Silverstone in 1960, so Jack Brabham came from behind and battled with Graham Hill, a Pom and the local favourite. And finally, Jack won that battle and took the checkered flag, and he went on to win the 1960 World Championship as well. And Paul had a black and white photo of Sir Jack in his room the whole time he was at Forbes Chambers. Paul had many favourite drivers. Jack says they're all passionate, fearless, supremely talented, comfortable in their own skin, but approachable and down-to-earth, no-nonsense racers. And every one of those things described perfectly Paul Byrne, the man, and Paul Byrne, the advocate. And I'll come back to say something about that, a little more about that. But I have to tell you about some more dumb cases. Markaleski and the Queen. Important case decided by 5 judges of the Court of Criminal Appeal. There was a conflict between the court when there were 3, and so they decided to bring in 2 more judges, and so I decided to bring in Paul Byrne. And that case gave rise to what has become known usually as the Markaleski direction, and trial judges are required to tell a jury in cases involving multiple counts based on more or less the same evidence, that if there's any doubt about one count or any doubt about a particular witness, that must be considered in considering the question of proof beyond reasonable doubt on the other counts. MFA was another case like Markaleski, which involved mixed, what we tried to persuade the court were inconsistent verdicts. At the special leave application in Sydney, The court didn't need to hear from us. They just called on the prosecutor, gave him a hard time for 5 or 10 minutes and then granted special leave. So we travelled down to Canberra pretty confident, lost 6-0. But the 3 judges who had granted special leave had to sort of, I don't know, avoid the shame of it and wrote a nice judgment about how the CCA hadn't quite approached it correctly. But that case remains one of the critical cases on the question of mixed verdicts and how that informs the question of whether a verdict is unreasonable. The other case is Mackenzie and the Queen. So in the great traditions of the New South Wales Bar, where one only speaks cases where one was triumphant, or at least where the loss is not reported in the Commonwealth law reports, we won't mention MFA again. Other than to say this, Paul drove me to Canberra. Paul did all the work. Paul paid for all the meals. Paul drove me home. And when we got home to my place, where he went out of his way to drop me, he jumped out of his big comfy BMW 7 Series, ran around to the back, pulled up the boot and got out a present for me. And that's the present, a little perfect model car. He really was an outrageously generous man, and he loved stationery, especially dyno tape. And you'll see there he's marked the date of the hearing with the awful letters MFA. Anyway, he also gave me another perfect car, little model Ferrari. I think that's my favourite one, and they're both up here. Anyway, that's the Ferrari. Paul tells me that Princess Grace used to drive around Monaco, specially designed for her. My perfect little replica Ferraris, neither of which is red, remain in my chambers in the Supreme Court to this day, and it's my shrine to Paul. There it is. I disrupted it for tonight's special event. And you'll see at the bottom on the baseball obsession shelf, the little green artistic ball that was purchased by Paul at the Guggenheim Museum, Bilbao. He was there and he just saw it and decided that I had to have it. So he just bought it and brought it back to Europe for me. And he did that stuff for people all the time. You know, he would just send people magazines because they'd spoken about a subject that interested them. I wasn't special, but Paul made me feel special. Antoun, the Antoun brothers were charged with demanding money with menaces. Their defence was that they did demand the money, they did do it with menaces, but that they asserted a claim of right. It was not an attractive defence. But during the judge-alone trial, the trial judge refused a number of applications, asserting that the judge was disqualified from hearing the trial on the grounds of apprehended bias. The problem started when a no-case submission was made at the end of the prosecution case. And bear in mind, this is a judge-alone trial, no jury. And the judge refused the application without hearing from counsel. Counsel protested and insisted on being heard, and the judge relented and said, right, well, when I've heard those submissions, will you be ready to proceed with the defence case? It wasn't going so well for the Antoun brothers. A second application based on the reasons for that decision was also refused, and then partway through the defence case, the judge announced that he was going to revoke bail, and then he did. That prompted yet another application for his honour to disqualify himself. They were convicted. And Justice Sully presided over the bail application, and he described with his typical directness and eloquence, I do not think it could be contended sensibly that the learned trial judge approached the question of the revocation of bail with anything like the particularity required. Anyway, the New South Wales Court of Criminal Appeal found a way to dismiss their appeal anyway. Anyway, the High Court overturned that, saying that it had the unmistakable appearance of prejudgment, and the CCA decision was overturned in spite of the unattractiveness of the defence claim of right, which the Chief Justice, Murray Gleeson, said was optimistic in the extreme. So I think I should be cautious that we're not going to go over by too much anyway. I know we started late because Jack was late, just saying. There are two more big cases decided after Paul's advocacy. And then I've mentioned already that I've blocked Lavender out, so we're not going to talk about that, but that's another important case. Another one was Weininger. Both losses, so I don't know what's happening in my mind when I prepared this speech. But he was so much more than an appellate lawyer. And that's why I want to move away from the High Court, because from everything I've said so far, you'd probably think, well, he was a great appellate advocate. But the thing I haven't mentioned is the most remarkable thing about Paul Byrne was he was as brilliant in a trial court or doing a quick plea in the local court as he was in the High Court. There's very few lawyers achieve this. We know many great appellate advocates, but you wouldn't let them loose in front of a jury. We know great jury advocates, but many of them couldn't find their way to the Court of Appeal unless given very, very clear directions. But Paul was a persuasive and courageous advocate at every level of the court system, and I was fortunate to appear for a co-accused on a couple of occasions and learnt a lot. He was courteous always, he was persistent always, he was prepared beyond belief always, and he believed in the case. He wasn't one of these defence lawyers who call their clients scumbags or call their case a loser. In fact, he almost never had a bad word to say about anyone. I don't think I can remember him saying anything bad about anyone. Justice Danji told me that the harshest thing he ever heard Paul say to anyone is, "I can't cop that bloke." That was it. In one of our joint trials, Paul asked one of the most effective questions I've ever seen in cross-examination. He was cross-examining a police detective and was being interrogated as to why he hadn't investigated particular aspects of the case, and his evidence was becoming increasingly silly and probably dishonest, justifying the failure to investigate. And at one point the detective came to the end of a very long, non-responsive answer, and Paul just looked at him with those big wide eyes and said, "Oh, come on." Now, "oh, come on" is not a submission that gets much traction in the appellate courts, but in that trial court room that day in front of that jury, it was absolutely devastating. The jury loved it, and the copper was toast. And the jury loved it because they loved Paul. They trusted him. He was so obviously sincere and honest. That wasn't a question or "come on," but it was a culmination of days of attentive, honest and courteous advocacy. Another moment in a different trial that I cherish was about an expert witness, a doctor who gave evidence for the prosecution about an alleged sexual assault, and I had cross-examined the doctor at a committal thing, a historical relic that you can read about in the history books. And I knew he was dangerous and partisan, and we had agreed, which I think means Paul told me, that I would go first in cross-examination. And Paul could feel my anxiety levels rise as the doctor walked to the witness box. The doctor was very dapperly dressed for his big day out and his performance, and he swaggered to the witness box, and my stress levels were high, and Paul just gently reached across the bar table and gently touched me on the forearm and said very quietly, well, actually not very quietly, "Don't worry, son, no jury believes an expert who turns up wearing a bow tie." I've got little headings throughout this speech, and this one says, "Even the prosecutors love Paul Byrne." And I know this to be a fact because he was never aggressive, he was never losing his cool, he was never impolite or discourteous to his opponent. Every prosecutor that I've spoken to remembers Paul fondly. They knew he would be honest, they knew that he would never rely on dirty tricks, they knew that he would never embarrass them in a courtroom, and he knew that he was unerringly polite and decent. Having said that, I'm told on very good authority, and let's hypothetically call that authority Justice Natalie Adams, that there was a wanted poster at the appeal units of the Crown Prosecutor Chambers, and the wanted poster was for Paul being wanted for late submissions. So that 100% rings true to me. He was always late with submissions, and he would be pleased to know that Oliver, who helped me today with the last version of the PowerPoint display, and the Chief Justice who didn't, would be proud of the fact that we finished still writing the speech just a little while ago, because he was always late. One Friday afternoon I was stressing out about some submissions where we got an extension after extension, and was due at 4 o'clock, and he just couldn't get what was worrying me, because he said to me, "Don't worry, there's no actual relevant distinction between 4 p.m. on Friday and 9 o'clock on Monday." My next little heading is, the next little heading is why we loved him. I think one of the most important things we learned from Paul is not so much was how he practiced life, but how he practiced law, but how he lived his life. The racing car drivers that he loved were approachable and down to earth, and so was he. He listened to everybody. There was just no arrogance or ego in him. I mean, there probably was, but you just never saw it. It was never on display. He took the view that there was no monopoly on being right, and he certainly didn't have it. So he would listen to the most junior solicitor and assess their thoughts and ideas with exactly the same mind that he would listen to a former High Court judge or a silk. Justice Natalie Adams told me that she was a relatively junior lawyer in the CCA unit at the DPP, and she watched Paul run lots of these appeals in the Court of Criminal Appeal and was struck by his courtesy and good manners. And she was a big fan, and she held Paul in awe. She assumed Paul didn't know who she was, really. And then one day at court, he came running up to her and said, "Hey, Nat, I've got a tricky one today. What do you think about this?" And asked her all sorts of questions about the facts of the case and law, because he wanted her opinion. Showing good judgment, I might say, but came as a shock. Ali Rami, hi Ali, was telling me a story the other night at dinner about being a junior solicitor who had just started in the law. He came up to Forbes Chambers to deliver a brief on an appeal. He'd read the case, but he'd never met Paul. He went into the room, was confronted by this ordered chaos and this kind of crazy professor-looking man sitting in a Recaro racing driver's chair and surrounded by paper and expensive stationery and a perfect little model cars, and asked the somewhat silly question, I'd have to say, of whether Paul was into Formula One. Well, Ali was too, and they chatted about Ayrton Senna and Alain Prost and Michael Schumacher for about an hour, when Paul finally said, "I suppose we better talk about your appeal." And months later, 6 months later, Ali saw Paul rushing into the Downing Centre late, and Paul saw him and diverted, came over and spoke to Ali. Couldn't believe it. Ali could not believe that Paul remembered his name, but of course he did. And Jason Barakat, who was with us at dinner that same night when Ali told me that story a few weeks ago, Jason said the same thing happened to him, and being astonished that this senior practitioner was interested in this baby lawyer's opinion, and then remembered him months later. I have a friend from country Queensland called Scott. He's now a reasonably distinguished artist, but in those days he was a moderately successful graphic designer in Brisbane, and he came to Sydney for love and quickly became an unemployed graphic designer. He had no work. I'd just moved rooms in Chambers and asked him if he wanted to do some painting to paint the walls. So he came in, and in the process he met a lot of the people from Forbes Chambers and met Paul. I'd bought Paul's room, which became Hammett Dangy's room, and Paul had moved into the fancy room, which Hammett and I both followed him into over the time. But the room was fitted out in, I suspect, very expensive wooden bookcases and shelving. Paul had the idea that there must be a way to transform the room so that the shelving was shiny and black like the Duco of a racing car. And this would be better to display his helmets and tiny little perfect racing cars, of course. So Scott was commissioned to make this transformation, and he was in the room for months, fastidiously putting coat after coat after coat of paint on this wooden shelving. And I sent Scott a text and asked him for his memories of Paul, and I just want to share some of the things he said. He said, a gentleman in the true sense of the word, paper everywhere, but order with his F1 paraphernalia. I was in there for ages. He never showed the slightest impatience with the slow job and quite possibly the slow operator. Whatever was happening in court, he was charming and genial company in his chambers, despite drop sheets, fumes and the air of chaos. It was actually a terrible job to do, but he was such a good bloke that it didn't matter. He made me feel like a colleague rather than the help. And that's how Paul treated everybody. His courtesy and charm, people loved. He was unflappable in court. He was a pretty shit cricketer. But he tried real hard, and we loved him. So the lessons we can learn from Paul, always be prepared. There's always something else you can do. There's some authority you can read or some other investigation you can make. Know your file, know your brief, know your client, know your victim, and always know the source of power and jurisdiction of the court that you're in. Always be polite and courteous. Treat everybody with respect and common decency. Have a passion, have an outlet. I haven't mentioned country music, but Paul was once jumped on stage at the Revesby Workers' Club to join Gene Pitney. Gene didn't know what had happened, but Paul loved his country music. But the passion that he had for racing cars and Formula One and travel and country music just took him outside of the stress that he must have always been under. Because if I was waiting on submission, so are another 20 people. Be generous. You can't take it with you. My ex-partner once said of Paul, and we were sitting in a nice restaurant in California, that Paul Byrne should write a book anywhere on $1,000 a day. Paul always tried to pay and generally succeeded. He treated the staff at restaurants well. He tipped big. Be brave, be cheeky, make trouble. It's the least you can do. Make that ambitious submission, but always have the goods to back it up. Consider the opinions of everybody. There's no monopoly on being correct. I'm going to tell one last story. That's Paul outside the Guggenheim Bilbao, where he bought me that beautiful baseball. I just want to thank Tila Reid, who wasn't able to make it tonight, but who helped me with the acknowledgement of country. I want to thank Jack Byrne for the beautiful stories he told me and shared. There was about 40 or 50 other racing car stories that I didn't get to. Thank you to Oliver and Teresa for putting up with me. I suppose I should include Robert Beach-Jones as well, and Oliver for the beautiful slideshow. Gabby Bashir also shared a lot of thoughts. So thank you to you all. But there's one piece of advice that I wanted to share before I stop, and you'll have to excuse the language. Paul very rarely used cuss words, as the Americans would call them. But we'd had a few drinks one night, and I'd saved a little bit of money and I was in two minds as to how to spend it. I had my eye on a new car. I'd never owned a new car, and it was a beautiful looking Peugeot 406 coupe in British racing green with tan leather seats, and it was designed by Pininfarina, which I'm told is a good thing. And on the other hand, I also had in the same pool of money an OK deposit for an investment property, and I asked Paul what he thought, because you ask the person if you want to hear the answer, you know. And anyway, we'd had a few drinks and he looked at me real hard and he said, people in Sydney are always talking about investment properties. Well, I say, you can't drive around in a fucking investment property. It was absolutely terrible financial advice. But I got the French coupe. So let's all have a drink to Paul. Thank you.
Thank you very much, Justice Hamill. It was a very funny speech, and a couple of themes that have really come through over the years with the Paul Byrne Memorial Lecture are how nice a man Paul was and how brilliant and versatile an advocate he was, and both of those themes came through really well tonight. Thank you very much, everybody, for coming along tonight. Before you go, I mentioned at the beginning of tonight's proceedings the Paul Byrne SC Memorial Fund, which was set up over a decade ago, and it aims to honour Paul Byrne's interest in the criminal law and the criminal justice system. And also it helps to fund the Institute of Criminology's activities, and we invite you to consider making a donation to that fund before you leave tonight. Thank you very much.